So my title today is Medicinal Cannabis, Trying to Keep Up with Shifting Legal Provisions. But before I get going, just a few disclaimers. I serve on a number of SAPRA advisory committees, but most importantly, I was on the MCC Cannabis Working Group, and I chair the SAPRA version of that committee. But I'm speaking here as an academic and not on behalf of the authority or any of its advisory committees or task teams. But if I use the pronoun we, you'll excuse me, because often it is about what we have been doing or what we hope will happen. So I'm going to give you a bit of background, just a touch of chemistry, talk about the global regulatory system and South Africa's legal equivalents, then the evidence that we have for therapeutic value of cannabinoids, and the current and envisaged provisions for legal access in South Africa. And I'm focusing predominantly on medicinal purposes, but you'll be aware that we're undergoing dramatic changes in relation to what might be called recreational use of cannabis. So I was in a spa the other day and I spotted this. And I wondered, is this legal now? Was it legal always? It's probably been around for ages, but there's a growing number of these products on the market. They're not new, of course. I had the chance to go to the Royal Pharmaceutical Society Museum last year, and there I saw cigarette indienne, especially for asthma, containing belladonna and cannabis. But on the right-hand side, you'll see Cannabis USP from Park Davis, and next to it, Cannabis BP from Allen and Hanbury. So these were official in our pharmacopoeia. They've been around forever, partly because this stuff grows everywhere. You might see mention of Cannabis sativa or Cannabis indica. Indica is just the plant that grows in India, but there's probably no difference between sativa and indica, and there's certainly more variation within those two species than there is between them. Cannabis is consumed recreationally both as the herbal product, the dried leaves and the flowering tops, or as a resin, hashish, and then as an oil, either distilled or extracted. For medicinal purposes, a whole range of different dosage forms have been made, from tablets to capsules to oils to buccal sprays to inhalations to e-cigarette refill liquids. But some of those are made rather informally. For industrial purposes, low THC containing hemp products are grown for their fibers. They've been on the market for a long time. And in fact, in this country, we've enabled the growth of low THC hemp for the last 20 years. They're used for all sorts of things, from car dashboards to ceiling tiles. Within the human body, there are a range of cannabinoid receptors, CB1, CB2, and they're very widely distributed. They're in all sorts of tissues, not only in the central nervous system, but in the gastrointestinal tract, the liver, fat cells, skeletal muscle, macrophages, in our bone. They've also got poorly understood and poorly characterized immunological effects as well. The reason that those receptors are there is to bind with endogenous cannabinoids, which are endogenous neurotransmitters. And many of the research projects are looking to engage with that cannabinoid system using chemicals that are not themselves cannabinoids. However, the exogenous cannabinoids that we are interested in are those constituents of the herbal plant itself. Cannabis, like all plants, has many chemical constituents. There are probably at least 489 different chemicals in cannabis, of which 70 at least are cannabinoids. But for the purposes of regulation, we really are focused on only two. Delta-9 tetrahydrocannabinol, or THC, is the psychoactive ingredient, interacts with a number of cannabinoid receptors. When that was first brought to the market as a medicine, it was given a separate name. It was called dronabinol, but actually that's just THC. It was also synthesized, and that got registered as nabilone. But again, these are all the same chemical. It really is just THC. The other major cannabinoid that is of interest from a regulatory perspective is cannabidiol, CBD. Cannabidiol enters the central nervous system, but is not psychoactive. And the first product which hit the world market and was eventually registered in 18 countries was from GW Pharmaceuticals. And they did a 50-50 mixture of THC and CBD. But then confusingly, they gave that mixture a new name. They called that nabiximols. And that product was made as a buccal spray. I said I'd give you some chemistry. We've got to at least give the chemists in the room a structure to look at. What's important here is that the synthesis of THC and CBD comes from one central process. So if a plant is synthesizing a lot of THC, it will not make a lot of CBD. Conversely, if it is synthesizing a lot of CBD, it will have a low THC content. And what breeders around the world have been able to isolate is particular strains which will give you either all THC, low CBD, or all CBD, low THC, or a mixture of the two, an 80-20, 60-40, in whichever direction you want to go. What this does mean is that if you are growing a low THC product, it's probably got a lot of CBD in it. And that might make things complicated or could solve our problems as we go forward. So let's look at international regulation. And for most of us, this should be relatively well-trodden turf, but I'm going to just remind you of some of the components of it. So within the whole United Nations system, the technical committee that starts any debate around the regulation of any chemical substance is a World Health Organization expert committee, the Expert Committee on Drug Dependence, so the ECDD. The ECDD can make recommendations. It makes them, because it's an expert committee, directly to the Director General of WHO, who then makes those recommendations to the Secretary General of the United Nations. But the body that takes the decision is the Commission on Narcotics Drugs, which meets in Vienna. The body that does the oversight of our countries living by these rules is the International Narcotics Control Board. So it monitors countries that have signed up to the single conventions, the 1961 Single Convention on Narcotic Drugs, the 1971 Single Convention on Psychotropic Substances, and the 1988 Convention on the precursors that are used to make some of these substances. Currently, cannabis and cannabis resin, so cannabis as a herbal preparation and cannabis resin made from that herbal preparation, are listed in two schedules, Schedule 1 and Schedule 4 in terms of the 1961 convention. The logic behind this is that anything which is listed in both of those schedules has no therapeutic use at all. So that's the first decision the ECDD has to make. This stuff has no possible use in humans, and therefore it is appropriate to make it prohibited, to make it banned, and to make its possession a criminal offense. What's really important is that the fact that cannabis is in Schedules 1 and 4 is not something that was decided in 1961. It was inherited from the 1923 Opium Commission. The reason that it's actually in the 1923 list of banned substances is the fault of South Africa. It was Jan Smuts who, as Minister of Justice at the time, proposed to the League of Nations when they were hosting the Opium Commission in 1923 that cannabis was so dangerous that it should be included with opium as a banned substance. And I would really encourage you to look at Tembisa Vetchen's work. Tembisa is a historian at the University of Johannesburg, and she's covered not only the cannabis story in some detail, but also why we've got the regulations that we have and the way that we reacted, for example, to the Chinese laborers brought to work on the gold mines on the Witwatersrand, who incidentally had a special license to buy opium as long as they bought it from a pharmacy. So we've always been supplying all of these things. So what's happened in relation to cannabis more recently? It's been a slow review process. So the ECDD in 2016 considered what they called a pre-review document on cannabis and cannabis resin, beginning to look at the science behind it, but not making recommendations. They did a pre-review on cannabidiol in 2017. In 2018, there was a special session looking only at cannabis and cannabis resin, the extracts and tinctures made from that, THC and other isomers of THC. But most importantly for us, the 41st ECDD that met in November last year made a series of recommendations which are now going to be tabled next month in March at the Commission on Narcotic Drugs in Vienna. We will be represented there by DIRCO, our International Relations and Cooperation Department, and they will vote on South Africa's position on cannabis in the CND, and they currently are meeting with SAPRA to get input as to what that vote will be in the CND. But like all of these international organizations, they leak. So already Forbes magazine has put out an article saying that the World Health Organization has recommended reclassifying marijuana under those international treaties and gave some details of that. I can confirm to you that the letter that they put on the web is genuine. It is the original letter. I'm not going to break the confidentiality of that, but there you'll see the letter signed by Tedros to the Secretary General of the United Nations saying, here are the recommendations of the ECDD. And if you want to read the background papers, so not the decision yet, those are not yet on the website, but all of the input papers around THC and CBD, cannabis and cannabis resin, they're all on the ECD website, and you can find those. So what about this country? How are things organized here? So we have a very complicated and overlapping system of control. For us, from a pharmacy perspective, our starting point is always the Medicines Act. So we have the Minister of Health, our National Medicines Regulatory Authority, SAPRA, and within that we have an advisory committee, the Names and Scheduling Advisory Committee, that makes recommendations on the scheduling status of substances. The schedules themselves are made by the Minister of Health in terms of the Medicines and Related Substances Act 101 of 1965. So although a recommendation is made by a committee, it then gets approved by the CEO and transmitted to the minister. The schedule doesn't take effect until it's gazetted. And we've seen some of the dramas that we've had around that with slow gazetting of decisions, for example, around the anti-malarials. What is decided by the Minister of Health is also communicated to the Minister of Justice, and the Drugs and Drugs Trafficking Act also has a set of schedules that are subtly different from, but informed by, the schedules from the Medicines Act. Those then enable the National Prosecuting Authority to take action against someone found in possession of a substance that is in the banned category. But there's another player, and that's the Minister of Social Development, informed by the Central Drug Authority and operating in terms of the Prevention of and Treatment for Substance Abuse Act. And that's the therapeutic interventions around those people who have got substance abuse disorder or the prevention of those sorts of disorders. And it's the Central Drug Authority that is also involved in deciding what is or is not in the prohibited category. So where are we with scheduling at the moment? Well, we are kind of stuck between decisions and gazetting. So if you look at the current schedules, now remember that we only gazette changes. So what SAPRA does is it puts together a consolidated document. But actually, that is a subsidiary document to the Gazette. The Gazette is the real thing. But you'd have to go right back to 1967 and find what was in the Gazettes. We've occasionally done a complete reissue of the Gazettes in the schedules, but it's not something that's done on a regular basis. At the moment, cannabidiol is listed twice. It's listed in Schedule 4 and in Schedule 7. And the one is a mirror image of the other. So it's cannabidiol when intended for therapeutic purposes is in Schedule 4, and then in Schedule 7, it's cannabidiol except when intended for therapeutic purposes, within brackets saying that's in Schedule 4. Then we've got dronabinol, within brackets delta-9 tetrahydrocannabinol, because it's the same thing. When intended for therapeutic purposes in Schedule 6, if it's not for therapeutic purposes, it's therefore in Schedule 7. Although it's not written there in the same way, it's captured in cannabis and in brackets, nice South African dacha, the whole plant or any portion or product thereof except A, when separately specified in the schedules, that's where the out is for the THC in Schedule 6. And then there's a whole section about processed hemp fiber and a definition of what it means to be processed. And that was a change made way back in 2000 to enable the growth of low THC hemp products. Now, I've put a couple of bits there in red. The reason is that the decision has already been made to take out the bit after the comma in the Schedule 4 inscription for cannabidiol. So cannabidiol will be a Schedule 4 substance only, with no mention of cannabidiol anywhere else. But that is only either a herbal preparation which has mostly cannabidiol in it and almost no THC, or an extract which is just pure cannabidiol, or an oil which is predominantly cannabidiol with a negligible amount of THC in it. If there's a medicinal product that is containing THC or a combination of THC and cannabidiol, then the rule is that the higher schedule applies, and that would be a Schedule 6 substance. We are also in the process, but that hasn't yet gone to the Minister for Gazetting, fixing up that last bit around hemp to remove this issue of if it's got seeds in it or hasn't got seeds in it. We're informed that the major consideration here is, can you assess the THC content? And if the THC content is less than 0.001, then that's fine. We don't care what's in it, if it's heads or seeds or leaves or stems or anything, as long as it's got no THC, you can't use it for psychoactive purposes. Why is that first change so important? There's a preamble to Schedule 4, which is the same preamble that's there for Schedule 1, 2, and 3, but is not there for 5, 6, 7, or 8. And it says all substances referred to in this schedule are excluded when specifically packed, labeled, sold, and used for industrial purposes, including the manufacture or compounding of consumer items or products which have no pharmacological action or medicinal purpose, and secondly, analytical laboratory purposes. So my hemp shampoo is an industrial product intended for consumer purposes. It's not intended to cure your epilepsy by washing your hair. It's making no medicinal claims, and therefore it would escape scheduling, and it is entirely a legal product, as long as it hasn't got THC in it. And that applies to many products that are currently on the South African market. We have an incredible range. We already have cannabis containing CBD only beer. Cool drinks are coming. Cosmetics have been in the market for years. We've had a hemp range in one of our major cosmetic houses that's been on their shelves with nice green labeling for more than a decade. So this is not new at all. The Act itself still causes us some problems. So in Section 22A, it's a little bit unusual that instead of a definition being at the front in Section 1, we now have a new definition inside a section. And this is the definition of medicinal purposes. And this says, in relation to a particular drug, medicinal purposes means the treatment or prevention of a disease or some other definitive curative or therapeutic purpose, but does not include the satisfaction or relief of a habit or of a craving for a particular drug or any other drug. That makes no sense. What it says is that in order to do something which is non-medicinal purpose, you have to do that in a government hospital or a hospital specifically licensed for that purpose by the Ministry of Health. And yet we dispense and sell, even at Schedule 0, nicotine replacement products, which is there to satisfy a craving for nicotine. And we dispense methadone, the biggest methadone program in the country. 1,600 patients on chronic methadone is right here in this city. So our legal system is not perfect, but changing the Act is a lot more difficult than changing schedules or even changing regulations. What we have seen over the last few years is a slow evolving attitude to cannabis. The first of these was published in 2016 in SAMJ. It was a position statement on cannabis signed by the chairman of the Central Drug Authority. But interestingly, it says for the executive committee of the Central Drug Authority. The Central Drug Authority could not agree on this statement. The EXCO could, and the EXCO published a statement without the whole authority agreeing with it, and raised the issue of a changing attitude to cannabis, and that perhaps it should not be sitting entirely in this banned category with the assumption that it had absolutely no therapeutic purpose whatever. There was immediate criticism, so Keith Scott in Cape Town wrote to the journal saying that he hoped that the next CDA position or the National Drug Master Plan would reflect a more scientific evidence-based approach to the broader drug problem, because it's not only cannabis that we need a change of heart about, it's absolutely everything else that is abused. By the way, that National Drug Master Plan has now been delayed for about 3 years. We still aren't seeing a final version coming out, and the previous master plan, they are dated, and the previous one expired in 2017. The rest of the world has been moving forward. So there's been a slow spread across American states over a period of about 40 years, allowing greater and greater access to medicinal cannabis, not recreational cannabis. But there wasn't a change in federal law, and banking in the US is federally controlled, so all of these businesses have had to run in cash, because as soon as they put the money in the bank, then the bank is accused of aiding and abetting a criminal enterprise. So even there, it's not worked that well. But other countries started to adopt the same approach. And in particular, I'll come back to South America, because that's where the really big changes happened. But what could you use medicinal cannabis for in these places? 1996 Californian law gives you a hint. It said you could use cannabis for any serious medical condition, but it didn't define what was serious. It was left to the discretion of the medical practitioner. And so you've had this growth of so-called dispensaries, not pharmacies, but dispensaries that was selling medicinal cannabis. Even in the US, we've seen individual states allow recreational use. Colorado and Washington State in 2012, Alaska and Oregon in 2014, California in 2018. You can see on the east, they're a bit more resistant. The further west you go, the more likely you are to be able to smoke your joint. But the big shift came in 2013 in Uruguay. And of course, Canada caught up last year. So here's some of the details of what the Uruguayan law stated. It said licensed pharmacies could sell consumers up to 40 grams of cannabis per month. They had to have fingerprint recognition systems that allowed monitoring so that you couldn't go to more than one pharmacy and buy more than 40 grams in a month. The clone of cannabis that was grown was genetically marked and could only be grown in government plantations. It's a relatively low THC version of cannabis. There's a ban on advertising. But you could grow your own. So a household could have up to 6 cannabis plants and harvest 40 grams per month. Or you could make a club. You could get 10 users, get together, plant 60 plants, harvest 400 grams, but everybody could only take 40 grams home. And they said marijuana, cannabis, could be consumed in the same places as tobacco. So you couldn't, if you couldn't smoke there, you couldn't smoke cannabis there. The problem with this law, first problem, is nobody spoke to the pharmacies first. They just changed the law and then told them they had to be the suppliers of cannabis. So immediately, the member organization of FIP came to us in Bangkok in 2014 and said, please will you help us tell our government to get lost. We did not go to university to be drug dealers. We don't want to sell cannabis. And at the time, in the council meeting, I put my hand up and I said, do you supply methadone in pharmacies in Uruguay? And they said, yes. I said, shouldn't we look at this a little bit more carefully and look at the harm reduction logic behind pharmacies being the suppliers of cannabis? So we agreed to prepare a reference document, which was finalized in 2017, and in 2018, a statement from FIP was issued. We gave advice to governments and to pharmacists and their member organizations. And apart from the broader picture of harm reduction, we said, where appropriate, governments must engage with pharmacists and their professional associations around the question of cannabis for medicinal purposes, with a view to developing rational and effective policies in this regard. And we asked pharmacy associations to engage with their governments to do the same thing. At the time, we also had wording in there about recreational use, because there is evidence, and there was literature from Germany dating back to 2009 that said if you really want to control a legal cannabis market and remove it from a criminal enterprise, you must give it to somebody who is trusted and has experience in controlling medicines that have abuse potential. And that's pharmacists. But at the last minute, those words were removed from the statement. So we've kind of left that on the side. But there are associations around the world that are saying we should be the place where cannabis is sold. What does it do when we use it for medicinal purposes? This is one of the systematic reviews that has attempted to look at the available literature. It's by Penny Whiting. It was published in JAMA in 2015. The conclusion of this systematic review was that there was moderate quality evidence to support the use of cannabinoids in the treatment of chronic pain and spasticity. Spasticity is the indication for which that Nabiximols 50/50 product, a buccal spray from GW Pharma, was first made. There was low quality evidence suggesting that cannabinoids are associated with improvements in nausea and vomiting in chemotherapy, in weight gain and HIV infection, in some sort of benefits in sleep disorders and Tourette syndrome, but that cannabinoids are associated with an increased risk of short-term adverse effects, like the psychoactive effects that you would see. That sort of euphoriant effect would be considered an adverse effect if you're trying to treat some sort of therapeutic indication. It's worthwhile looking at the PRISMA diagram to see the flow of studies. So they started out with 23,000 hits on the database, brought it down in the end to only 79 randomized controlled trials. 56 of those are in nausea and vomiting and chronic pain. And as you go down that list, you'll see that for some of them, there's only one RCT, but look in brackets at the number of patients. Anxiety disorder, one RCT, 24 people. You can't really tell much from that. The quality of evidence isn't great. And even if we look at that claimed benefit in HIV patients, 4 RCTs, combined 255 patients. Absolutely scanty evidence. An example of the better evidence is, of course, the Nabiximols, which had been registered in 18 different countries. So that was 27 milligrams of THC, 25 milligrams of CBD per mil, and you used 8 sprays every 3 hours, up to 48 sprays buccally every 24 hours. And there were 19 placebo-controlled studies in spasticity, pain, nausea, and vomiting. The forest plot shows you that even in that area, this is improvement in pain, with one study from Abrams looking at THC alone, and all the rest of the studies being from either GW Pharma itself or others using the same product. But the results are discordant. The net result is on the side of favoring cannabidiol, but it's only just statistically significant. And those wide confidence intervals are a reflection of the small number of patients in those studies. You look at that 2010 example, there are just 15 in the cannabinoid group and 14 in the placebo group. GW Pharma hasn't stopped there. They've now got a second product on their list called Epidiolex, and I'll come back to Epidiolex in a minute. That's a CBD-only product. In this country, in order to inform the debate, our Medical Research Council put out a statement on cannabinoids for medicinal use, but based it entirely on the Whiting systematic review. There are other pieces of information, and I want to take you through one that looked only at the HIV/AIDS picture, and I was a co-author of this one with Elizabeth Lutke and Andy Siegfried. So this was a systematic review of medicinal use of cannabis for reducing morbidity on all symptoms and mortality in patients with HIV and AIDS. We started with 726 abstracts and eventually selected 65 papers for full text review and eliminated all but 7. The 7 had very different endpoints, so we couldn't do a meta-analysis. We could only get a qualitative sense of what was going on there. An important part of a systematic review is to try and get a sense of the quality of the evidence and how biased it might be. And this is a risk of bias graph showing the percentages of those 7 studies. Green is good, yellow, we're not so sure, red, it's really bad. So look at blinding. Most of these studies were around increased appetite in HIV/AIDS patients conducted before the antiretrovirals came out. So this is when wasting was a major problem, and trying to get HIV/AIDS patients to eat more was why they were trying to use cannabis. The cannabis was administered in this way by smoking. So how do you blind somebody giving them a tobacco product or a tobacco and cannabis mix? So lots of attempts were made to do that. They smoked through a nozzle with a perspex shield between them and the burning end of the joint, but of course they inhaled and exhaled inside this side of the container, and therefore they could smell whether it contained cannabis or not. Almost all of the participants in these trials were users of cannabis. So they were asked afterwards, could you tell which was the placebo and which wasn't? And 70% of the time they could identify the active from the placebo. And of course, they'd all grown up with the idea that smoking a joint gave you the munchies. The end point was that there were snacks lying around, and they would weigh the snacks beforehand and they'd weigh the snacks afterwards to see how much they'd eaten. And if they thought that they were getting the munchies, they ate more snacks. And so what you could really tell about whether this was a good idea to use in HIV, we thought was pretty slim. And of course, they were all short duration, so we didn't know much about safety. They were all done before combination ART. We called it HART at that stage. And we felt that the evidence was slim in terms of substantial effects on morbidity and certainly no evidence in mortality. That doesn't stop people asking for cannabinoids. So here's a paper in the BMJ saying, should doctors prescribe cannabinoids? And the advice given at this time in a British context was that doctors should discuss in a dispassionate and non-judgmental and supportive manner the advisability or otherwise of using cannabis to palliate certain symptoms. And we should be clear with our patients that there's no evidence for effectiveness in treating pain, for example, and benefits are likely to be modest. Here's a Canadian attempt also looking at pain relief, but aiming this at anesthesiologists. And yeah, they were a little bit more positive, saying the recent literature supports the idea that currently available cannabinoids are modestly effective analgesics, and they give us some sort of opportunities. But here's JAMA at the end of 2016 saying, don't forget that this stuff has side effects, or at least THC does, from dry mouth to sedation to hypotension to ataxia to dizziness, all of which can lead you to some other risks of motor car accidents or falls or things like that. Pure CBD, this JAMA later felt was not that much of a problem. And it pointed out that no one had ever died of an acute overdose of cannabis alone. It is a relatively safe compound. Because of the incredible problem that North America has with overuse of opioids, 72,000 people died last year in America of opioid overdoses. They've begun to look at cannabis as an alternative to the opioids. And they feel it could be a substitution. If somebody is coming in demanding opioids repeatedly, one way that might be safer is to push them towards cannabinoids. But I want to show you how quickly this evidence is changing. So here's a Cochrane review from 2012, so it's not that old. It's only 7 years old. And it was looking at cannabinoids in epilepsy. It found just 4 studies with a total of 48 patients, and said no reliable conclusions can be drawn at present regarding the efficacy of cannabinoids as a treatment for epilepsy. It was safe to give 200 to 300 milligrams of cannabidiol, but it was given to small numbers of patients for generally short periods of time, and long-term safety could not be dealt with at all. But on the 20th of April last year, the FDA panel recommended approval of Epidiolex, a CBD-only product in Lennox-Gastaut syndrome and Dravet syndrome. Those are 2 impossible to treat epilepsy syndromes in children. The numbers of patients are small, the studies were really tiny, but the evidence is there that it makes a difference. And that's why we've seen around the world the 2 cases in the United Kingdom that resulted in the change of policy in that country are epileptic patients who had traveled across to Canada to go and find the product and had it confiscated when they arrived back in the UK. A number of countries have tried to build access to cannabinoids into specific legislation around what's called the right to try. And the attempt in this country was by Mario Ambrosini, the late IFP Member of Parliament, who had an untreatable lung cancer. He was a non-smoker, and non-smokers who get lung cancer have very poor outcomes. And he tried everything, including cannabis. But he wrote into this piece of legislation the most amazing attempt to make cannabis available. He wanted in this bill to say, notwithstanding any other law, but subject to the Constitution, no one shall be liable or guilty of any offense for growing, processing, distributing, using, prescribing, advertising, or otherwise dealing with or promoting cannabinoids for the purposes of treatment or commercial or industrial uses. And then he defined cannabinoids as any part or chemical constituent of the plant known as cannabis, marijuana or dacha, or any genetic modification thereof, any extract thereof, any product containing it or resulting from the processing thereof. So a very unusual way to define the chemical by saying now the plant is the chemical. SAPRA took quite a hard line on this, and so did the MRC. And in November 2017, persuaded the Portfolio Committee on Health to finally abandon the Ambrosini bill. Ambrosini's bill was the very first private member's bill ever to make it into debate. Up till then, they'd all been thrown out. But he'd gone to the Concord to say the Constitution allows a member of Parliament to table a bill, and therefore his bill had to be debated properly. But we finally killed it because we could argue that there was a legal mechanism to get the access that he wanted in the bill. We didn't have to make a new piece of law. The existing law was there. A guideline was therefore published by the Medicines Control Council in November 2017 on the cultivation of cannabis and the manufacture of cannabis-related pharmaceutical products for medicinal and research purposes. The legal basis for this lies in 2 pieces of the legislation. 22C1B is an altered part of the Act which now allows SAPRA to regulate the producer of active pharmaceutical ingredients. So it's not only finished pharmaceutical products, but active ingredients that can now be a license from SAPRA, and therefore you could get a license to grow cannabis from which you could make oil or some other product. And then section 22A9 says no person shall acquire, use, possess, manufacture, or supply any Schedule 7 substance or manufacture any Schedule 6 substance unless he or she has been issued with a permit by the DG. So we could use 22A9 to license somebody to then take that cannabis product and turn it into a medicine. They could grow it because when it's not for therapeutic purposes, it was Schedule 7, and they could then make a medicine out of it, which would become a Schedule 6. And of course, if it's a CBD-only product, then it could be a Schedule 4 product. In doing this, we looked at two examples, the Canadian example and the Australian. And in Canada, they've got licensed growers and their licensed products that are available on the market that are quality-assured cannabis-containing products. Australia is still importing. They're not producing any of their own, but they import predominantly from Canada and the Netherlands. So there's the application form, which you can fill out. It's not overly prescriptive. It sets principles and says, for example, you must explain to SAHPRA how you're going to grow this under controlled circumstances, how you're going to ensure that the plant that you grow doesn't crossbreed with the plants that are growing outside of the fence, because remember, it grows everywhere, except Antarctica. And you must have quality control so that the product which you put onto the market doesn't have pesticides in it, doesn't have heavy metals in it from the extraction process, or the way that you process it to turn it into a cannabis-containing medicine. More recently, a publication has finally been sent out by SAHPRA giving feedback on what progress has been made in relation to these particular products. So as of February 2019, there have been 56 patients who've been given Section 21 approval for importation because there's no locally registered or available or licensed source. They are importing from Canada or the Netherlands. There were 21 applications for a license to cultivate. One is withdrawn. By February 16 had been inspected. 4 were scheduled for inspections. None of them yet met all of the requirements, but many of them had great potential and were indicating that they could meet the requirements. So I can't tell you the names of those places, but one of them was in fact set up by the Agricultural Research Council to produce low THC hemp in a controlled environment under hydroponic conditions within a closed room. Perfect for growing cannabis for medicinal purposes. Another one was a specialist tomato grower. Again, had the fences, had the buildings, had the controlled soil conditions, could do exactly what we want. But there is no legal, locally produced medicinal cannabis product on the market yet. So any product being sold at the moment, claiming medicinal purposes, whether it contains THC or CBD or any mixture of those, is illegal. If it is not medicinal, and if we get the final gazetting of our CBD inscription into the statute books, then those would be entirely legal. And no one's going to go and prosecute them while we wait for the gazette to come out. Of course, everybody is trying to do these non-medicinal products. This was an article I found quite interesting recently in Bloomberg, pointing out that getting THC in particular into beer or other alcoholic beverages wasn't so easy because it's lipid soluble. So people were talking about emulsions and microspheres and all sorts of ways of getting this lipid soluble product into an aqueous environment. But even in this country, on the 7th of February, Westgrow, the trade promotion body in the Western Cape, said they're optimistic about investment potential of medicinal cannabis. The first of our neighboring countries, Lesotho, has already licensed one grower, but they plan to provide an export market. They could bring it into this country if they got a 22A9 permit. then the court stepped in. And then the Prince judgment, which took 3 different cases that had been decided in high courts or were pending in high courts and joined them all together, the unanimous judgment of the Constitutional Court was that Section 4B of the Drugs and Drugs Trafficking Act was unconstitutional. Section 5B of the same act was unconstitutional, only as applies to cannabis. And that Section 22A9A1, the very section I said we were relying on, of the Medicines Act is constitutionally invalid to the extent that it renders the use or possession of cannabis by an adult in private for that adult's personal consumption in private a criminal offense. That's unconstitutional. The effect of that judgment is that Parliament has 24 months to revise the 2 acts, but in the interim, the acts are revised by the court in that wording is read into those acts. So, for example, it says, the following words and commas are to be read into the provisions of 22A9. After the word unless, insert a comma and say, in the case of cannabis, he or she being an adult uses it or is in possession thereof in private for his or her personal consumption in private. They like to do the in private twice. Or in any other case, comma, you need a permit from the DG. So we're in a weird situation. For any purpose, recreational, medicinal, the Court didn't differentiate. If you want to use cannabis alone, at home, in private, you can. How'd you get it? Court didn't say. It somehow fell from heaven. And now you had it and you could use it. But you couldn't buy it, you couldn't sell it. You could grow it at home, but where did the seeds come from? Hopefully you had them before the Court. So right now, and I'm not going to show you the detail because I can't, the Department of Justice is busy drafting the regulation of cannabis bill. And we will go to Parliament with a completely new bill which will do the sorts of things that Uruguay said. How big can your plant be? Can it be more than this big or wider than that much? How much can you take off of it? And where can you get the seeds in order to start your own cannabis factory at home? Importantly for pharmacists, societal views on the prohibition of cannabis for recreational purposes are changing. What we believed in 1922 and in 1923 was predominantly based on a racially defined view that said the other is doing the wrong thing and it's affecting us. So white society in this country looked at Indians in particular, bringing cannabis and all of the traditional uses of cannabis in Ayurvedic medicine as sweetmeats that we served at weddings, and said this thing is dangerous. They even believed it caused brain damage, and therefore because it's the other, we must deal with it the same way that we did with the Chinese mine workers. The Chinese got sent home, and then the opium went home with them. Can't send the Indians home, but we can ban it. And then we convinced the whole world to do the same thing. It's taken nearly 100 years, but that's unraveling. Many patients desire access to cannabis or cannabinoids despite the lack of evidence. And we have to give them the advice based on science and then find ways to protect them from unintended consequences. There is still a lack of access to standardized regulated products on our market unless imported under Section 21. But what we can do is if somebody comes to us and says, should I buy this thing that I found on the internet? You can say to them, I don't know what that thing is that you're buying. It could be poisonous. It could just be olive oil and green food coloring, for which you're paying 2,000 Rand for 50 mils. What I can do is help you fill in a Section 21 application and buy something which we know is of good quality. Might not do very much, but if you get some benefit from it, you can use it. Parliament, of course, has the 24 months to fix Section 22A9. We'll see that probably the Cannabis Bill go to Parliament and then the subsequent changes to Act 101 and to the Drugs and Drugs Trafficking Act, because the courts have had the final say. And pharmacists need to be ready to respond to these changes and to offer clear, evidence-informed advice to the public. And I hope I've given you some things to think about, and I'll take your questions hereafter. Thank you.